This is East Idaho Newsmakers with Nate Eaton.
Thanks for being with us today. Sexual assault, sexual harassment, the Me Too movement, these are all issues that have been talked about a lot nationally and even locally within the past year or so. And today, that is what we are discussing here on East Idaho Newsmaker. Joining me is Danny Clark. He is the Bonneville County Prosecuting Attorney, along with Amanda Ulrich. She is an attorney here in town, here in Idaho Falls. And I want each of you, could you just give us a brief introduction about each of you? Amanda, we'll start with you.
Sure. So my name is Amanda Ulrich, and I'm a civil litigator, and the majority of the work I do is in employment law. So I deal a lot with sexual harassment cases, discrimination cases, and sort of employment-related civil rights cases.
Excellent. And Mr. Clark?
I'm Danny Clark. I'm the Bonneville County Prosecuting Attorney. I've been a prosecutor for a little over 16 years. I've been the elected prosecutor for about 4 years. Part of that, I've either handled or supervised cases of sexual assault for about 8 of those years. And so I've got quite a bit of experience. It's good to be here with Amanda. I think she's one of the foremost experts in employment law around here, so I'm looking forward to hearing from her.
And I look forward to speaking with both of you. We've thought about doing this for a while, a show about this topic, because there's so many unanswered questions and a lot of people just don't know, including myself, about this. And with the Supreme Court hearings this past week, we thought it was appropriate to do it today. So the first question, what is the difference between sexual harassment and sexual assault?
Okay. You want to go ahead?
Sure, and so I can address the sexual harassment aspect of that question. Sexual harassment is generally, it comes up in the employment context, and sexual harassment is essentially any kind of unwanted sexual comments, conduct, gestures, jokes, those sorts of things that are potential bases for causes of action, and that would potentially violate the law.
So a touching?
A touching would be part of sexual harassment, yes.
At what point does that escalate to sexual assault?
Well, I think that's a good definition, because this harassment covers lots of different activities and not just the touching. Sexual assault is a generic term that's used interchangeably kind of throughout the country. Assault, by definition, is either an attempted touch or a threatened touch. In Idaho, battery is the more appropriate term. And so while harassment covers things aside from attempted or completed touchings, sexual assault or sexual battery is the unlawful touching of another. And then if that's of a sexual nature, it puts it into a different category of crime. So it's the touching itself that raises it to an assault.
Which is a crime. Is sexual harassment a crime?
I think it depends upon the level of the sexual harassment. So, and maybe Danny can address this a little more as well, but if the sexual harassment is something that involves a touching, a groping, and there's even been cases where people have been raped at work, I believe that would also fall into the category of a crime.
Sure. I think the best way to answer this is to go outside of the realm of some of the statutes we're thinking of, the sexual crime statutes. You've got the assault, that's defined one way. Harassment can also include emails and stalking someone.
Texting,
phone calls. This repeated harassment of a sexual nature. Well, those crimes may not be sex crimes, but there's crimes for stalking someone, repeated unwanted contact. You have telephone harassment, repeated aggressive and perhaps of a sexual nature harassment via phone or email. And then you have any of those kinds of crimes could, although not of a sexual nature, could still constitute crime that would feed off of the harassment that was going on either in the workplace or otherwise.
Okay, so let's talk about some scenarios. I believe that with the latest Les Moonves, the head of CBS, who was just lost his job over these allegations. There was an elderly woman in her 80s or 90s who walked down to the LAPD to report that years ago, decades ago, he had sexually assaulted her or harassed her. Let's say that's me, that 15, 20 years ago, somebody did something sexually toward me and I never reported it, and I feel with all of this talk that I should do it now. What do I do? Where do I go?
That's probably for me. You know, I'm going to give you a very simple answer to a complicated scenario you just gave. There's a statute of limitations for different types of crime, and depending upon the conduct, whether there is a statute of limitations. Very simply put, generally a misdemeanor offense is a 1-year statute of limitations. A forcible rape, there's never been a statute of limitations. That could have occurred forever ago. Doesn't matter.
Meaning, as a misdemeanor, you have 1 year to report it.
Correct. Well, 1 year to bring charges since the event.
But with a rape, in Idaho, there's no statute of limitations.
Correct. And then about 10 years ago, I'm going off memory here, about 10 years ago, they removed the statute of limitations as to any offenses on a child. So offenses of a sexual nature toward a child, there was also not a statute of limitations anymore. So my point is, there's no simple answer to your question because it depends on the type of crime. The best way to answer it would be this. If you've been, a crime has been committed against you like this, report it to law enforcement. We'll find out whether it's something that's prosecutable or not, but that shouldn't be the reason not to report it.
Sure.
Unless you're absolutely certain they can't bring charges. That shouldn't be the reason not to report it.
But that could be when the civil end of things could step up, right, Amanda?
Sure, and I guess with the civil side of things, I think you're looking at two areas. You're looking at both the employment anti-discrimination side of it, and you're looking at potentially civil torts as well. So looking at it from the employment discrimination side of it, the statutes of limitations for those particular statutes are relatively short. So if someone has experienced some kind of sexual harassment at work, they have to bring what's called a charge of discrimination, which is this initial administrative process you have to go through within 300 days of the event. So it's very short. And actually there's sort of two systems that we have to deal with employment discrimination. There's the federal statutes and there's the Idaho Human Rights Act, which is the state statute equivalent. And they govern essentially the same types of conduct, but they can apply potentially in different scenarios. So with the federal anti-discrimination statutes, which includes Title VII, which would govern sexual harassment, that statute of limitations is 300 days, but for it to apply, there have to be 15 or more employees of that particular employer.
Really?
Yes. So sort of the stopgap for that, for smaller employers, is the Idaho Human Rights Act. Now that act has a 1-year statute of limitations, the same sort of legal standards for sexual harassment and other discriminatory actions apply, but that only requires 5 employees to be applicable. So, so if you're in a scenario where you're at an employer with fewer than 15 employees, but there's more than 5, there are still protections for an employee in that situation.
But you basically have a year.
You have a year under the Idaho statute. Under the federal statutes, you only have 300
days. So if my boss sexually harassed me a year and a half ago, I won't have a civil case.
Right, right. Not under Title VII or the Human Rights Act. Right.
So I guess if someone is watching and this is happening now, it's obviously better to do it, to report it as soon as you can, criminally and civilly.
Yes, absolutely.
Certainly.
Have you all seen in the past year an increase in the number of cases being reported with the national attention, being focused on this?
I can address that first, and I would say we haven't necessarily seen an uptick in sort of general sexual harassment reports, but we have seen a bit of an uptick in sort of more serious sexual harassment / sexual assault cases going on at work.
So not necessarily an increase in the number, but the increase of the
severity of
the
what's been reported.
They've been more severe, more serious.
Right.
And how about on the criminal end?
That's an interesting question. Generally, the data across the country would say that sexual assault crimes in general are down, but the number of people reporting per occurrence is up. So in other words, I think from the work you guys do and other people do to kind of shine a light on this and to put it at the forefront so that people are dealing with it in society, I think that's caused more to come forward, more to be comfortable, more to report, more prosecutions. That's gone up. But the number of occurrences occurring, I think, has actually gone down. That's what the data shows at this point. And that's a good thing. We've got more people comfortable reporting, less of it happening. Mm-hmm. And I think that's a good thing.
So I have a friend in the South who is a man, and he's in a managerial role, and he calls people honey. It's just a Southern thing. And he has told me recently that he is now not afraid, nervous to call his employees honey and to give them hugs. Do we need to be that careful? I mean, it's this kind of gray area, but what advice would you have for guys that might be scared that, oh, I don't want to get sued, I don't want to be charged?
Sure. So I think it's fair for him to be concerned about that, and it's always good to err on the side of caution. And I think that question kind of goes to the crux of what the major issue is with sexual harassment and sexual assault is you've got this power differential problem. So you mentioned your friend is a boss, and for him to hug someone or call them honey, if this person is a subordinate to him, that person, because of his role as a supervisor over whoever he's hugging or saying honey to, would probably be a little bit hesitant to say, I'm not comfortable with that, please don't do that, please don't touch me. So that's where people run into problems. So I would always advise someone who's in a supervisory role to avoid hugging and saying honey or sweetheart or anything like that, if possible.
And criminally, really, I mean, you've got to have enough evidence if you're going to charge somebody, enough probable cause to bring those charges forward.
Sure.
So what would you say to people, to men that have felt that they have been sexually harassed by women? We don't hear a lot about that. We occasionally see a woman who's charged with sexual assault against a man. Is that becoming more common where guys are willing to step forward and say, you know what, me too? Or are we seeing that much in Eastern Idaho?
I don't know that I have seen a lot of it here, but I don't doubt that it goes on. And I think not only can you have a male employee who's being harassed by a female employee, you can have a male employee being harassed by other male employees. You can have a female employee being harassed by other female employees. And anytime that happens, absolutely, report that. Stand up for yourself because you do have rights. And not only do you have rights to report that, you have rights to not be retaliated against for reporting that. So there are protections in place for people who do feel like they need to report something has happened.
And that leads to my next question. I think in one of the major scandals with one of the national news networks, some of the women that reported the allegations were told, well, why didn't you go to HR? And they said, well, the boss controlled HR. And it wasn't until an outside litigator was brought in to investigate, an outside counsel was brought in to investigate, that they were able to talk. A lot of people feel that way. I can't go to HR because we have the same boss and it's going to get back to the boss. What should you do?
Right. So in those kind of situations, I would say first have the employee, if someone's experiencing problems with sexual harassment in the workplace, take a look at your employee manual. Hopefully there is one. And that employee manual should tell you who to go to, and not only one person, but alternatives if the person that you would normally report to is the harasser. So there should be several avenues for reporting. If you're still not comfortable with the individuals identified in that personnel handbook, go to someone else in management who you trust. And if all else fails, you can go to the EEOC or you can go to the Idaho Human Rights Commission and make a report and file a charge of discrimination. And the EEOC or the Human Rights Commission can then send out that charge, put the employer on notice that there's stuff going on and it needs to stop.
So there is help outside of the company, but obviously try to resolve it as close to home as you can, or report it at least.
Correct, yeah. It's important that the employee kind of goes up the chain of command if possible.
Some of the sex crimes that your office has had to deal with, and a lot of the offices, are just horrific. And some of them, especially when children are involved, we read through these documents to report it, and we try to give as much, tell the audience as much as we can to let them know what is alleged, what happened, without getting too graphic, because it's upsetting and it's disturbing. How do you personally deal with that?
Well, I've talked about this. You've asked me before about the hardest things I deal with, and child abuse and child sex abuse is easily the most difficult thing we deal with. On one hand, I can just mechanically do my job as a lawyer and prosecute cases and remove myself completely emotionally from the trauma that's gone on. I don't think I do as good of a job if I handle it that way. My lifespan probably goes up by a few years, but I don't think I give the case the dedication and the effort that it needs. And so I would prefer myself and my deputies to be vested in the case and care about it. And I think they do a better job that way. But it's hard. It's hard to deal with when you see those things. I've got stories and stories and years of cases where it's been traumatic, and they're certainly hard to deal with, no question.
And I think we've talked about this as well, but it's worth making the point. The difference between lewd conduct and rape, a lot of times, we'll report on one of these crimes and instantly the Facebook warriors go on and say, why wasn't he charged with rape? Why is it just a lewd conduct charge? But we've discussed the sentence is you can get life in prison for either one. And talk about why you would charge with a lewd conduct if someone's alleging rape.
Yeah, generally, just in a nutshell, rape is the forcible sex act against someone else. So if there's force involved like that, that's removing whether the person's a minor or not. When there's force involved, that's a forcible rape. That's certainly very, very egregious. When you're talking about lewd conduct with a minor, you're talking about a child under the age of 16, and the age of the perpetrator is much older. Lewd conduct is generally viewed as much worse than a statutory rape, in other words, a rape based on age difference. Lewd conduct is considered much worse, and the sentences are much more severe for that charge. So that's why, and that's really the distinction. The courts get a sentence on the conduct that happened. The name of the charge rarely really applies other than to bring the jurisdiction before the court.
At what point, Amanda, should somebody, if they realize their boss is harassing them, it's not enough to go criminally. Nothing criminal has happened, at least at this point. They've reported it to HR. At what point do they need to involve counsel? At what point do they need to come to your office and say, I've had enough?
Well, and I think that's going to depend upon the person. In order for there to be a cause of action for sexual harassment or any other kind of harassment-based discrimination in the workplace, the harassment has to be severe or pervasive. So generally, if there is, one offhand comment or a joke, that's generally not enough for a case. It's certainly something that shouldn't happen and should definitely be reported to HR if someone's uncomfortable about a joke, for instance. However, if there's a repeated pattern of conduct and it's reported and it's not stopped, absolutely come talk to an attorney. If it's conduct that's very severe, such as groping, grabbing, all the way up, unfortunately, to rape, absolutely come talk to an attorney, and we can help you with that.
Yeah, I think partly Amanda doesn't want to say, hey, come talk to me every time. but I'll say it. Look, if the person is unsure of how to proceed and what to do, consult an attorney to work through that. What we want to make sure is that whomever's going through this, whether it's severe or minor, depending upon society's perspective of it, if that person feels bothered by something that's going on and they're not sure how to proceed, consult someone to help you do that. That's the key, regardless of what the conduct is, I would say.
And one of the things that we have here in Eastern Idaho is Building Hope Today for help with victims that have experienced these horrific sexual crimes. And you're on the board for Building Hope Today. For those people that haven't heard about it, tell us a little bit about what you guys do.
Well, Building Hope Today is an organization founded by Matt Morgan through his own experience, and that's based upon the time restrictions of bringing a civil suit against your abuser. He was able to do that much later based upon a fraud theory.
And he won.
And he won that, absolutely. And I used that case, or that theory, in a criminal case. And that's the reason for the connection 18 months ago. But Building Hope Today is about strengthening cases of child sex abuse in order to hold more offenders accountable. And I can't think of a better movement to be a part of than that. It's been a wonderful organization. We've seen success by using them, and we're currently going around the country and training other law enforcement and prosecutors on strengthening their cases so that the success rate of the conviction rate can go up and more offenders are held accountable.
And you can find more information about them on their website and Facebook page. For both of you, question for both of you, what is the biggest misconception when it comes to this topic? I know that's a broad question, and I know this topic is a broad topic, but what would you have the audience know that maybe it might help them or might shed some light on something that is a misconception?
You want to tackle it first?
Sure, and I think I kind of touched on this initially, but there are protections for people if they feel unsafe at work or uncomfortable at work. So make sure that, don't be afraid to come forward and report if you're being sexually harassed, even if it's by, the head person at your organization. There's help. Go talk to an attorney, go talk to someone else you trust who's in management in the organization, because basically under the law, there can be no adverse action against you for reporting that sort of conduct.
Yeah, and whether this is a misconception or not, I guess one thing I'd like to say to any victims or survivors of sexual assault, if this has happened against you, please feel comfortable coming forward. Now, my office operates under this very simple assumption. The victim is telling the truth. Whether a case is brought is whether there's sufficient evidence to convict the defendant, whether there's sufficient corroboration to the disclosure, and that's what Building Hope Today is all about. It's the corroboration that decides whether we bring a charge. The corroboration dictates whether the victim is being truthful or not. So we don't go into the case questioning the victim's motives, the victim's ulterior reasons, whatever it may be. We take it at face value and just simply investigate it and the decisions made upon the evidence. So I guess my point is this: if something has happened to you, come forward. It will be fairly and fully investigated, and if we can hold the offender accountable, we will do so.
Well, that's very helpful. We're going to include a list of resources down below this video. You can go and see the resources locally. If you need help criminally, civilly, we'll include some of those as well. Amanda Ulrich, Daniel Clark, Bonneville County Prosecuting Attorney, thank you both for coming in here. This is a topic that I imagine will be continued to be discussed all across the country and the world for who knows how long, but it's something that is important and should be addressed. Thank you for watching. Have a good week.